Thank you, Chairman Stile, Ranking Member Morelli, members of the committee. I want to thank all of you for the opportunity to testify today. My name is James R. Copland, and since 2003, I've been affiliated with the Manhattan Institute for Policy Research in New York, a nonprofit public policy think tank, where I've long been a senior fellow and directed the Institute's legal policy research. Although my comments draw upon such research conducted for my employer, my statement before the committee is solely my own. Insider trading occurs when someone trades a security using material non-public information in violation of a duty of trust or confidence. Over time, federal insider trading law has moved from a concept of equal access to information to one based on fiduciary breach and later misappropriation, which extends to outsiders using confidential information for personal gain. Historically, neither of these fiduciary breach nor misappropriation theories, as traditionally understood, would necessarily have covered all government information, which is why this body in 2012 enacted the Stop Trading on Congressional Knowledge Act, or STOCK Act, which is the subject of this hearing. And that act explicitly clarified that members of Congress are not exempt from federal insider trading law. The act also clarified that members of Congress and certain other government officials or employees trading securities or certain other financial instruments based on non-public information gained from their official duties could constitute an insider trading violation. The act also heightened financial disclosure requirements for members of Congress and senior staffers, requiring disclosure of any purchase or sale of securities worth over $1,000 within 45 days of the transaction. As I outline in more detail in my written testimony, substantial evidence may suggest that Congress may not have been adequately self-policing under the STOCK Act. Though I want to emphasize that this is mostly due to a lack of evidence, which is not in itself dispositive evidence. Despite allegations of improper conduct, no member of Congress has ever been prosecuted under the Act, nor do any public records exist indicating whether officials have ever paid statutory fines for STOCK Act disclosure errors. Multiple legislative proposals have been introduced here in the 119th Congress that aim to go beyond the STOCK Act and/or to further restrict members of Congress from owning or trading securities. I go into each of these in some detail in my written testimony. At this time, I would just like to emphasize the important questions which arise in addressing these various vehicles for reform, each of which I discuss in more depth in my written submission. Should members of Congress be permitted to own or trade in any individual securities or other investment vehicles for which specialized knowledge gained from members' public positions might create at least an appearance of insider-type benefits? I want to emphasize that neither lawyers nor other fiduciaries nor corporate insiders are expected to have no ownership whatsoever in the securities of corporations to which they owe duties. But Congress may be a special case. Ownership of specific corporation securities or non-diverse funds may create an appearance of impropriety even if members are not profiting from buy or sell decisions based on insider information, because said securities ownership might be thought to bias members' voting decisions and other legislative activity in favor of personal benefit rather than the public interest. Is direct ownership enough to trigger concerns, even if a member exercises no control over securities purchases or sales, i.e. are blind trusts okay? What ownership should be excluded from blanket prohibitions, i.e. are there exemptions from the types of investments that we may not want to be covered in blanket prohibitions? What individuals should fall under the blanket prohibitions? How do we treat spouses, dependent children, and others? Do they get the same treatment? What tax treatment should be available or required for members forced to divest from certain securities according to new conflict of interest prohibitions? And finally, what enforcement mechanisms should exist? Is self-policing from this body enough, or do we want the Department of Justice involved or some other mechanism? I explore most of these questions in more detail in my written testimony, and I'm happy to explore each in more depth here today. I encourage members to ask questions, which I will endeavor to answer to the best of my ability. And I'm more than willing, of course, to follow up later with members and staff. Thank you again for your time and your invitation.